Good morning, Alex and friends. I'm Grace. Today is Tuesday, June 23rd, 2026, and you're listening to Alex's News. In Riverside today, we are looking at a high of 90.2 degrees and a low of 62.4 degrees, so please remember to stay cool and drink plenty of water if you find yourself spending time outside. As we move into our top stories, we will examine the legal reasoning behind a judge's decision to quash Department of Justice subpoenas that were targeting leadership in Minnesota. We are also looking at the factors that led the Supreme Court to reinstate the convictions of Pedro Hernandez. Plus, we have a variety of other stories to cover as we keep you updated on the events shaping our world. We have a packed show for you, so please stay tuned. Good morning, everyone. We're following a major legal development out of Minnesota that pits the state against the Justice Department. A federal judge has just thrown out a series of subpoenas targeting some of the state's top officials. Ethan, walk us through what happened here.
Good morning, Grace. So yesterday, on June 22nd, the U.S. District Court for Minnesota unsealed an order from Chief Judge Patrick J. Schultz. That order quashed 6 grand jury subpoenas that the U.S. Department of Justice had issued. These weren't aimed at ordinary citizens either. They targeted some of the highest-ranking leaders in the state, and the judge's language was remarkably blunt.
Who exactly were these subpoenas going after?
It was a who's who of Minnesota leadership. We're talking about Governor Tim Walz, Attorney General Keith Ellison, and Minneapolis Mayor Jacob Frey. The list also included St. Paul Mayor Keoli Herr, plus the Hennepin County Board of Commissioners and the Ramsey County Board of Commissioners. So the DOJ was casting a very wide net across both state and local government.
That is a sweeping list. What sparked this investigation in the first place?
It all traces back to something called Operation Metro Surge. That was an immigration crackdown the Trump administration launched back in December of 2025, so about 5 months ago now. The operation deployed thousands of federal agents for mass deportation raids across Minnesota. In the aftermath, the DOJ opened an investigation to figure out whether these officials' public opposition to the raids amounted to unlawful obstruction of federal immigration enforcement.
I understand the surge itself turned deadly. What can you tell us about that?
That's right, and this is the part that really raised the stakes. 2 U.S. citizens, Renee Good and Alex Preddy, were killed by federal agents in the streets during this period. Beyond that, the DOJ didn't just go after officials. They filed charges against other Minnesota residents who were protesting the surge, and those cases were significant.
What kind of charges are we talking about?
Well, prosecutors brought a conspiracy charge against 15 people who had been tracking immigration and customs enforcement agents. And there were federal charges against nearly 40 individuals following a protest at a church. What stands out there is that 2 of those individuals were journalists. So you can see why this drew so much attention and concern from civil liberties groups.
Let's get to the heart of it. How did Judge Schultz describe these subpoenas?
He did not mince words, Grace. The judge called the subpoenas, quote, extraordinarily broad, end quote. And here's a detail worth noting about the judge himself. Schultz is a George W. Bush appointee, so this isn't a partisan figure pushing back. According to reporting from The Guardian, NPR, and WHRO Public Media, he concluded there was, quote, no doubt, end quote, that the subpoenas were issued to harass political opponents.
That's striking language from any judge. What was his legal reasoning?
In his order, Schultz wrote that the Trump administration had been, quote, threatening and attempting to punish states and localities that have adopted sanctuary policies, end quote. He went further and said, using the grand jury process to coerce political opponents into taking official actions the federal government can't directly require is an, quote, unethical use, end quote, of the law. He framed that as a violation of the 10th Amendment. The court ultimately found that the, quote, dominant purpose, end quote, of the subpoenas was retaliation and coercion.
Did the Justice Department offer any justification for these requests?
They tried to. According to The Guardian and other reports, the DOJ pointed to 4 specific instances of conduct. There was a separation ordinance authored by a Minneapolis City Council member, and a statement about an eviction moratorium made by another council member. They also cited internal guidance from Ramsey County advising employees not to share information with ICE, plus Hennepin County training on how to handle ICE warrants and apprehensions.
On the surface, those sound like specific concerns. Why didn't they hold up?
This is where the judge really exposed the cracks. Schultz noted a glaring inconsistency. The DOJ didn't actually subpoena the Minneapolis City Council members who wrote that ordinance or made those statements. So if those were the real targets, why weren't they served? On top of that, the judge pointed out the department couldn't identify a single instance where a county employee actually obstructed a law enforcement officer because of their employer's policies.
So essentially, no concrete evidence of obstruction?
Exactly. The judge emphasized the DOJ had failed to provide even one plausible investigatory justification for these requests. When you put that together with the fact that they skipped over the people who actually wrote the policies in question, it painted a picture. The court saw it as political pressure dressed up as a criminal investigation, and that's why the subpoenas were thrown out entirely.
How are Minnesota's leaders reacting to all this?
They're celebrating, as you'd expect. Governor Tim Walz hailed the ruling as, quote, a victory for the rule of law and our democracy, end quote. He argued the DOJ was essentially pursuing criminal investigations into the president's political enemies. Mayor Jacob Frey also expressed his gratitude for the decision.
And what about Attorney General Keith Ellison? He's been at the center of these fights.
He has. Ellison has sued the Trump administration numerous times, including a lawsuit filed on January 12th of this year that directly challenged Operation Metro Surge. He described the court's decision to quash the subpoenas as an, quote, extremely rare step, end quote. And that framing matters, because judges don't typically toss grand jury subpoenas. It tells you just how far outside the norm the court believed the DOJ had strayed.
Has the Justice Department responded to the ruling?
They have, and they're standing firm. A spokesperson for the Department of Justice said it takes the, quote, unlawful obstruction of federal law enforcement operations extremely seriously, end quote. The spokesperson added that the department would continue to investigate these matters in compliance with the law. So this clearly isn't the end of the road from their perspective.
Is this ruling an isolated event or part of a bigger pattern?
It's actually part of a broader trend of judicial pushback, Grace. Legal analysts are connecting this to a similar case from March of this year. In Washington, D.C., Judge James Boasberg also quashed subpoenas tied to a DOJ investigation. That one into former Federal Reserve Chairman Jerome Powell. So you're seeing judges across different jurisdictions reaching similar conclusions about how the department is using its investigative powers.
What should we be watching for next as this story develops?
The big question is whether the DOJ tries to come back with narrower, more targeted subpoenas, since the spokesperson signaled they intend to keep investigating. We'll also want to watch how the other legal battles play out, particularly Ellison's January 12th lawsuit against Operation Metro Surge. And given that 2 U.S. citizens died during the surge, there may well be more scrutiny of the operation itself. This is a fight between federal and state power that's far from over.
Really important context there. Ethan, thank you so much for breaking it all down for us this morning.
My pleasure, Grace. Happy to be here.
Welcome back. We're following a major Supreme Court decision in one of the most haunting cases in New York history. It involves Eaton Patz, a 6-year-old boy who vanished back in 1979. Our reporter Chloe has been tracking this. Chloe, good morning. What did the court decide?
Good morning, Grace. So just yesterday, on Monday, June 22nd, the United States Supreme Court voted 6-3 to reinstate the murder and kidnapping convictions of Pedro Hernandez. He's the man convicted of killing Eaton Patz. According to PBS NewsHour, The Guardian, and Fox 5 NY, this ruling reverses an earlier decision by the U.S. Court of Appeals for the Second Circuit, which had overturned his verdict. So in plain terms, the conviction is back in place.
Before we get into the legal twists, remind us what happened to Eaton in the first place.
Of course. Eaton Patz disappeared on May 25, 1979, while walking to his school bus stop. It was the very first time he'd made that walk alone, in the Soho neighborhood of Manhattan. As Fox 5 NY notes, The disappearance terrified parents across the entire city. And it really changed how America responded to missing children. Etten was one of the first kids to have his face printed on milk cartons.
That's a detail a lot of people remember. Did this case leave any lasting mark beyond the milk cartons?
It really did, Grace. The anniversary of his disappearance, May 25th, was later designated as National Missing Children's Day. So nearly half a century later, this one little boy's case is still woven into how the country thinks about child safety. And remember, his body was never recovered. That absence has hung over every stage of this investigation and every court proceeding since.
So who is Pedro Hernandez, and how did he come into the picture?
Pedro Hernandez is now 64, and he lives in Maple Shade, New Jersey. At the time of the disappearance, he worked at a convenience store near that bus stop. But here's the striking part, Grace. He didn't become a suspect until 2012, more than 30 years later. In his confessions, Hernandez said he lured Etten into the basement of the store with the promise of soda, strangled him, and then discarded the body in an alley.
More than 30 years is an extraordinary gap. What happened once he was finally charged?
It was a long and difficult road to conviction. His first trial, back in 2015, ended in a mistrial after the jury became deadlocked. They simply couldn't agree. Then a second trial, in 2017, resulted in convictions for both kidnapping and felony murder. Hernandez was sentenced to 25 years to life in prison. So prosecutors finally had their verdict after decades of uncertainty.
But that conviction didn't stand for long, did it?
No, it didn't. The U.S. Court of Appeals for the Second Circuit later overturned it, and this is where it gets very technical, Grace. The reversal came down to a single interaction between the trial judge and the jury. The jurors had a question during their deliberations, and the way the judge answered it became the heart of the entire appeal.
Walk us through that question. What exactly did the jury want to know?
So the jurors asked whether they had to disregard Hernandez's later confessions if they decided his very first confession was involuntary. That first confession, importantly, was made before Hernandez was read his Miranda rights. The judge's reply was simple. He said, quote, "The answer is no," end quote. The Second Circuit later ruled that response was, quote, "clearly wrong," end quote, and, quote, "manifestly prejudicial," end quote.
And what did the appeals court think the judge should have said instead?
The Second Circuit argued the judge owed the jury a, quote, "more fulsome," end quote, answer. In their view, he should have told jurors they had the option to discount all of the confessions, not just the first one. So the entire reversal hinged on the completeness of that one instruction. It's a reminder of how a single sentence from a judge can unravel years of legal work.
Then this lands at the Supreme Court. How did it get there?
The Supreme Court granted an appeal from Manhattan prosecutors, led by District Attorney Alvin Bragg. His office pushed hard to get the conviction restored, and the justices ultimately sided with them in that 6-3 vote. In an unsigned majority opinion, the court ruled that the Second Circuit had, quote, exceeded its authority, end quote, by second-guessing how the state court handled the trial.
What was the legal reasoning behind that? It sounds like more than just this case.
It really is bigger than this case, Grace. As PBS NewsHour reported, the court leaned on a 1996 federal law, the Anti-Terrorism and Effective Death Penalty Act. That law was designed to limit federal oversight of state criminal trials. The court said federal habeas courts simply aren't permitted to disturb state court convictions by reevaluating the evidence or the reliability of confessions. So this ruling reinforces a real boundary on federal power.
You mentioned a 6-3 split. Who dissented?
The 3 liberal justices dissented, Grace. That's Elena Kagan, Sonia Sotomayor, and Ketanji Brown Jackson. Now here's something notable. They did not provide a written explanation for their position, so we don't have their detailed reasoning on the record, just the fact that they disagreed with the majority. In a case this prominent, that silence is a little unusual.
Let's turn to the reaction. What is District Attorney Bragg saying?
Bragg praised the decision. He had previously described the Second Circuit's basis for overturning the conviction as a, quote, slender reed, end quote. His argument was that the appeals court had fixated on that one jury instruction while ignoring a 5-month trial that involved 66 witnesses. So from his perspective, an enormous body of evidence was being set aside over a narrow technicality. The Supreme Court's ruling clearly validated that view.
And on the other side, how is the defense responding?
Hernandez's legal team is deeply disappointed. That includes his attorney, Harvey Fishbein. According to The Guardian, the defense maintains that, quote, an innocent man is in jail, end quote. Their core argument is that Hernandez's confessions were false. They say those confessions were the product of a mental illness that caused him to hallucinate, so they see this not as a triumph of justice, but as a real miscarriage of it.
That's a serious claim. Do they point to anything specific about how those confessions were obtained?
They do, Grace. The defense emphasizes that police questioned Hernandez for roughly 7 hours before reading him his Miranda rights and before recording the interview. That sequence is central to their concern about whether the confession was truly voluntary. Now, in fairness, Hernandez did repeat his confession on tape at least twice afterward. So prosecutors point to those recorded statements as strong corroboration of his guilt.
So where does this leave Hernandez right now?
With the Supreme Court's decision, his 25 years to life sentence remains in force. And according to Mr. Fishbein, Hernandez will not receive a new trial. So this really does appear to be the end of the legal road for the defense, at least on these grounds. For a case that began with a little boy walking to a bus stop in 1979, the courtroom chapter now seems closed.
A remarkable end to a case that spanned more than 4 decades. Chloe, thank you for breaking all of that down for us.
My pleasure, Grace. Thanks for having me.
Here are some other headlines. Across the pond, the political climate in the United Kingdom is feeling a bit stormy. Prime Minister Keir Starmer has decided to fold his hand, announcing his resignation as leader of the Labour Party this Monday, June 22, 2026. After devastating losses in May and rival Andy Burnham's crushing victory in the Makerfield by-election on June 19th, Starmer decided it was time to step down from the podium. Between a struggling economy and some policy flip-flops, things just didn't add up. The final straw may have been the messy appointment and firing of Peter Mandelson as United States ambassador due to ties with Jeffrey Epstein. Starmer will keep the seat warm as caretaker until a successor is chosen. Nominations open July 9th and close July 16th. Andy Burnham is already throwing his hat in the ring, while Wes Streeting is staying out of the race and cheering for Burnham. Closer to home, a federal judge has put a stop to the SAVE program. Judge Sparkle Suknanen ruled the revamped system unlawful, stating the government knowingly trampled on privacy rights. This ruling is a major blow to President Trump, as the program was a key pillar for scrubbing non-citizens from voter rolls. 25 states have used the tool to scan 67 million registrations since April 2025, but the court says the government crossed the line. In financial news, we are mourning the loss of a titan. Former Federal Reserve Chair Alan Greenspan has passed away at the age of 100. His wife, Andrea Mitchell, says he died at home from complications of Parkinson's disease. Greenspan steered the ship for nearly 2 decades and oversaw the second-longest economic boom in United States history. While he was a rock during Black Monday, some say his hands-off approach let the bubble burst, leading to the 2007 crisis. Current Chair Kevin Warsh is now following in those footsteps, keeping his statements short and spare. Turning to crime, a bitter pill to swallow in New Mexico. Reports suggest the DEA let hundreds of thousands of fentanyl pills hit the streets between 2023 and 2025. Whistleblower David Howell claims the agency poisoned the community just to build bigger cases. While the DEA says these tactics were lawful, critics say this willful blindness cost too many lives. Finally, looking at the Middle East, Israeli soldiers are still digging in their heels in southern Lebanon. However, there is a glimmer of hope as the 5th round of United States-mediated talks begins tomorrow, June 23rd, in Washington, D.C. While the ceasefire is holding by a thread, Lebanese President Joseph Aoun is making it clear that Tehran cannot speak for Beirut. We will see if these talks can finally break the deadlock. That's all we have for now. Today's episode was made by Alexander King with Claude Opus 4.8, Gemini Pro 3.1, Gemini Flash 3, and Google Cloud Text-to-Speech. I hope you have a great day. I'll see you tomorrow, Alex.